as a whole. And you know very well that India is known for its multiculturalism and ethnic pluralism, known for its solidarity and understanding others as well. You just see the policies or the legislations passed by the parliamentarian. Of course, they could be executed by executives, interpreted by judicial officers as well. As long as you are dealing with the legislature, executives, and the judicial officers, so long as you cannot be actually forgotten on the concept of the rule of law. The rule of law has been derived from many things. This is what we have emphasized on the basis of as many as schools of thoughts. One of the schools of thoughts on law is actually based on the natural law. Your Hugo Grotius, Oppenheim, Plato, Socrates, Aristotle, who have heralded transformational changes, especially in the holistic and integrated society as a whole. Of course, just because of our bread and butter, we have divided them into several pieces as well. In fact, when Aristotle started working on static sciences and social sciences, he did not make any distinction between static sciences and the social sciences as well. We need all of them. We need social sciences, none other than even political science as well. Perhaps you may have studied political science in a better way, along with the continuity of the law as well. Let me share with you, when I was actually pursuing my bachelor's degree and master's degree, or even in PhD, of course, static and social sciences, they helped me a lot to shape my knowledge as well. This is what many scholars may have known on the basis of the synergy between social sciences and the static sciences as well. In these days, so most of the time students are actually unable to understand basic sciences as well. I'm just insisting them to read and write basic sciences. So without understanding basic sciences, whatever you are going to say would be incomplete. And moreover, if rather I would say, when I was actually studying my jurisprudence, Western political thought was highly helpful. It was highly helpful, Western political thought. I could refer as many as thoughts exposed by great scholars, especially from Stoic philosophy, Roman philosophy, above all, synthetic jurisprudence as well. Of course, no matter American realism and the Scandinavian realism, they are from sociological approaches and the positive realism as well. So without understanding positivism or the socialism, it's very difficult to understand the realism as well. They should go hand in hand. This one thing. On the other hand, if rather I would say, you have already been crossed modernization. What's there in modernization? In modernization, you give more importance to capitalism. but it is not so in the case of postmodernism. Many scholars may have known about postmodernism. Now you are living in postmodernism. What is postmodernism? Postmodernism is nothing but a balancing approach between capitalism and the communism as well. The communism and capitalism, they should go hand in hand. You know why? In any society, haves and have-nots are remained, rich and poor are remained, developed and developing are remained, even today. Even in America, you can find the people who have come from little background. All people are not richer in America. All people are not richer in European countries. All people are not richer in India. People have come from little background. As I said in earlier session as well. Look into the people who have come from little background like tribals. This is very serious, thought to be called and looked into with a view to understand the synergy over here. On the other hand, if rather I would say, on the basis of philosophical foundations, bacteria needs to live. You are killing bacteria for our survival. It is true. Some bacteria, they are helpful for human being. On the other hand, prostitutes should have a choice. You cannot compel her to have your own, human satisfaction as well. Though you are well off, you have to respect women. Country like India. That's why laws are favoring women, because of historical injustice and practical denials as well. Let me share with you on the basis of a word crisis, as long as we are dealing with law, society, politics in post-colonial era. In colonial era, you were under the mercy of a few of them. They conquered, they administered. You were under the mercy of these countries as well, none other than UK, Portuguese, Dutch, and others as well. You did not find your own constitution, you did not find your own rights. You were under the mercy of these people, and you had just commentaries which were written by commentators. Take for an example, it could be Yagnavalkya Smriti, Manusmriti, Nadasmriti, Kautilya's Arthashastra, Agni Purana, Ramayana, Mahabharata. All in all, you had. They were not actually passed by any parliament. King was supreme, temple was supreme, mosque was supreme. Whatever they wanted to say was the law of the land. There was no scope for understanding law in general. Generally speaking, there was no concept of law indifferently. We had just dharma. Dharma prevailed for many years. Religious head was the judge and the magistrate. Whatever he wanted to say was the law of the land. Religious head was the judge and the magistrate. Whatever he wanted to say was the law of the land. Mauli was a judge. Father was a judge. And there is no scope for understanding rights of human being all along. This is very, essential with a view to understand the synergy or legal chemistry between law, society, and the politics as well. Why politics? What kind of society you have? To create a synergy between society and politics, how a law is an imperative. Of course, there is an impending need to understand law, society, and the politics as well. On the other hand, let me share with you on the basis of municipal law and international law. What is international law and the municipal law? Municipal law is called as national law of any country of their choice. Each state is a supreme in eye of law. It can pass any legislation, amend any legislation, and repeal any legislation. Such a kind of an autonomy has already been given to a state. They can decide whatever they want. The popular sovereignty is well noted. The supreme power of a state should be called and looked into. Supernos, perhaps you may have gone through them. Supreme power of a state. This is what in De La Republica. De La Republica. The Jean Bodin, who could share, king was actually unrestrained by any law of the land. He was supreme in eye of law. Later on, Machiavelli and rest of them, they started working on the concept of state. They include even social contract theory. Perhaps many scholars may have known social contract theory based on Thomas Hobbes, Locke, Rousseau as well. Thomas Hobbes once said, man is highly brutish, nasty, and force is ultima ratio. To overcome them, law is an imperative. Similarly, Rousseau exposed as many as a theoretical foundations with a view to understand the community interests as well. How exactly community interests shall be looked into, especially in the post-colonial era. So after having gone through the constitution and many setups, you have to understand your own rights as well. Of course, no matter when you are dealing with ongoing crisis at the international level, we have had as many as ongoing crises. Take for an example, you have world hunger, poverty, global warming, climate change, Yemen civil wars, Syrian civil war, Libyan civil war, Israel and Palestine conflict. They're all actually remain even today. Ukrainian conflict, war in Georgia, war in Chechnya, Korean conflict, Indo-Pak, Indo-China, Indo-Bangladesh crisis are remain even today. History repeats. So based on history, you are living. This is a very serious issue. You have to understand. Looking into the perspectives on the efforts made by United Nations system. In 1986, a declaration on right to development came in. Why declaration on right to development came in? With all hopes and ambitions, there is a meaning it. Please remember. What is right to development? This is what Amartya Sen said long ago. Right to development, which means economic empowerment or the development as well. You should have a purchasing capacity. You should not live in miserable conditions like poverty. That's why Dr. B.R. Ambedkar said long ago, ಮನುಷ್ಯ ಬಡತನದಲ್ಲೇ ಹುಟ್ಟೋದೇನು ತಪ್ಪೇನಲ್ಲ, ಆದರೆ ಬಡತನದಲ್ಲೇ ಸಾಯೋದಿದೆಯಲ್ಲ ಅದು ತಪ್ಪು ಅನ್ನೋದನ್ನ ಡಾಕ್ಟರ್ B.R. ಅಂಬೇಡ್ಕರ್ ಯಾವತ್ತೂ ಹೇಳಿ ಬಿಟ್ಟಿದ್ದಾರೆ. You should understand it. See, poverty that itself is violation of human rights. This is what former judge and chairperson of NHRC, you could say, Justice Anand said, poverty that itself is a violation of human rights as well. So in this way, being a teacher or a person who has come from good background should understand the society and the politics as well. This is one thing. Looking into the perspectives on gender violence. So as long as you are dealing with post-colonial India, gender violence is one of the major concerns. Look into rapes. They include gang rape. Delhi has become a rapist place. Look into marital rape, then digital rape. They are all actually ongoing. See the matters in connection to the subject matter of domestic violence, sexual harassment at working places, acid throwing, reproduction, coercion. then honor killing, dowry violence, forced marriages, forced prostitution, forced abortions. These are the major issues and challenges of women who are living in India in post-colonial mindsets. This is the right time to have some specific legislations with a view to overcome the problems of women country like India. We talk many things on gender justice. What is gender justice? Where is gender justice? Show me. How exactly gender justice should be called and looked into? This is very serious issue. You have to understand. ಬರೀ ಬಾಯಿ ಮಾತಲ್ಲಿ ಜೆಂಡರ್ ಜಸ್ಟಿಸ್ ಅನ್ನೋದಲ್ಲ, ಮಹಿಳೆಯರಿಗೆ ಹಕ್ಕು ಕೊಡೋದಲ್ಲ. ಹಕ್ಕುಗಳನ್ನು ಎಷ್ಟು ಕೊಟ್ಟಿದ್ದೀರಾ, ಎಷ್ಟು ಜಾರಿಗೊಳಿಸಿದ್ದೀರಾ, ಯಾವ ರೀತಿ ಅವರಿಗೆ ನ್ಯಾಯ ಕೊಟ್ಟಿದ್ದೀರಾ, ಸಾಮಾಜಿಕ, ಆರ್ಥಿಕ, ರಾಜಕೀಯ, ಶೈಕ್ಷಣಿಕ ನ್ಯಾಯ ಕೊಟ್ಟಿದ್ದೀರಾ, that you have to understand it in otherwise manner. Anyway, in this society, we do have many crises like, gay marriages or same-sex marriages, or you have living relationship or walk-in relationship. You have proxy marriages or antinuptial marriages. How in what manner you are going to understand these issues as well? We need to have some specific legislations to address these issues as well. When you deal with law in society, whether law changes the society or society changes the law, these are the few questions that shall be asked and cleared. I repeat once again, whether law changes society or society changes the law. Take for an example, in Nirbhaya's case, Babri Masjid's case, Shabarimala's case, we could find the constitutional morality. What is constitutional morality? How will you understand constitutional morality? Based on your constitutional interpretation. What is constitutional interpretation and the judicial interpretation? So how will you understand constitutional interpretation and the judicial interpretation? Especially in America, they give more importance to judicial interpretation. What the judges say is the law of the land. That's why it is to be called as a judge-made law. Judge-made law. They say that judge-made law is more superior than the law of the land. Whatever they wanted to say is the law of the land. That's very important from the point of view of understanding how a law changes the society, how society changes the law as well. In this way, you have to have a look on the concept of, what shall I say, the rule of law as well. This is one thing. On the other hand, when GATT was established in 1947, GATT was giving more importance to developed countries rather than developing countries. It was giving more importance to capitalistic movements rather than leftistic movements as well. Especially in 1960 and 1970, there was an awareness among these developing countries. People started questioning developed countries. They started learning, understanding. The education was fundamental for them to question the developed countries. When developing countries started questioning developed countries, in fact, in 1974, United Nations came out with a very good charter on economic rights and duties of sovereign states in 1974. Based on new international economic order, a declaration on right to development came in 1986. Later on in 2000, new millennium goals came in. So based on new millennium goals, you have sustainable development goals 2015 to 30. So how exactly these goals are helpful to you when you deal with law, society, and the politics in post-colonial era? That's why here you have to have a look on how, in what manner sustainable development goals, in which you have known them very well. We have 17 sustainable development goals. How exactly they are successful country like India? So mere rights are not sufficient. They are supposed to be enforceable. There shall be minimum effectiveness. That's what we have known them. There shall be recognition of rights. There shall be recognition of law. So without understanding these, so whatever you are going to say on the society would be incomplete. That's why I'm appealing you to have a look on the earlier history and lead your life. So this is one thing. On the other hand, see the human rights which are exposed on the basis of EDSR, Universal Declaration of Human Rights, International Covenant on Economic and Social Rights, 1966. Then International Covenant on Civil and Political Rights, 1966. Beijing Declaration, Vienna Action Plan. All these international covenants are highly successful with a view to understand the local problems as well. You have to understand the transformation of international human rights law into the municipal law, or transformation of international law into the municipal law. You have to balance the interest between municipal law and the international law as well. Don't be emotional on either side. These are the two eyes of our jurisprudence. Please remember, they should go hand in hand. To fill the gaps at the local level, please transform or incorporate or what shall I say, take some consensus with a view to understand the need for the public international law as well. Looking into the perspectives on the demands of society, many branches of public international law exposed. Take for an example, it could be law of sea, it could be air and space law, it could be international humanitarian law, it could be human rights law, it could be on private international law, it could be on international economic law, law of war. Law of war was actually divided into three: aerial warfare, naval warfare, land warfare. And law was also divided into several perceptions and the ideologies as well. As I said, each state is a supreme in eye of law. It can pass any legislation, amend any legislation, and repeal any legislation. Such a kind of an autonomy has already been given to a state. Just see Article 1 and 2 of the UN Charter 1945, wherein you have given some inputs to a state to look into the matter very seriously. That's why if somebody is actually crying in India, that the state should know why he or she is actually crying. That's our concern. So in this way, you have to understand ongoing crisis and the gender violence in India. These are the things should also be actually called and looked into. On the other hand, lots of public interest litigations were actually filed before honorable high courts and the Supreme Court as well, with a view to understand the local issues as well. Issues in connection to child labor, issues in connection to women, issues in connection to orphans, issues in connection to children, issues in connection to LGBT, sex, issues in connection to IDP, internally displaced persons. They include even refugees as well. Who are all refugees? Have they come from other countries? Yes, they are from other countries. You know why? Because of well-founded fear and persecution, which is well noted under UN Convention on the refugee status 1951, wherein it has outspoken on the refugees. So how exactly refugees are supposed to be protected? Who's this responsibility? This is one thing you have to understand. Of course, the efforts made by UNO in this regard is actually well accepted and the received. Take for an example, UNHCR, United Nations High Commissioner for Refugees, which was actually established on the basis of Refugee Status Convention 1951, is to be called and looked into. You have to understand them. So without some organizational setup or institutional setup, it's very difficult to sustain the life of human being. So in this way, the efforts made by UNO and its half-century enactment should also be actually called and looked into. So in this way, please remember to note some classical issues and challenges all over the world, especially in the Democratic Republic of Congo. There were too many interesting cases occurred. Take for an example, prosecutor versus Lebanga, then prosecutor versus Bemba. Lebanga and Bemba, they were actually responsible for mass killing of people in Democratic Republic of Congo. They were responsible for child abuses and forcible prostitutions when they were actually administering in Republic of Congo as well. Therefore, you have to understand in this around 25.4 million people in the need of a humanitarian crisis in the Democratic Republic of Congo, especially in Ethiopia. The similar cases we are finding. In Nigeria, for example, 7.3 million people are in risk of food insecurity. Especially in Somalia, 4.3 million people are suffering even today. They are facing crisis levels of food insecurity. Especially in Myanmar, Burma, 8.6 million people are suffering from food insecurity. South Sudan, 9 million population is suffering. See, who are responsible? And how exactly these problems should be resolved? This has to be looked into with a view to understand the law, society, and the politics as well. This is one thing. On the other hand, if rather I would say, few countries are in fact launching so many satellites into the orbit. And you are talking more on UNFCCC, United Nations Framework on Climate Change. Sun has family members. You are disturbing him. Now, outer space has no space because of your greediness and commercial activities in outer space or military activities in outer space. You have launched a series of satellites into the orbit. This is very serious issue you have to address. Simply, you cannot keep quiet. Your outer space has become, majestic, Bangalore majestic. You have been actually keep launching so many satellites into the orbit unnecessarily. So therefore, you have to think even from these perceptions and the ideologies as well. So keeping in view of all these introductory remarks, let us understand law, society, and politics in the post-colonial India as well. Of course, some laws are inherited. Many laws, particularly in areas like intellectual property and environmental regulations, have roots in colonial era. Perhaps you may have gone through some specific legislations like Bern, Rome, Paris Conventions, which were actually drafted on the basis of colonial mindsets. They are there in almost all the legislations which are dealing with intellectual property rights. Say, for example, it could be copyright, trademark, patents, integrated circuits, geographical indications, and many more. So most of the legislations are all based on the colonial mindsets. Please remember to understand these. So therefore, I'm just insisting you to have your own legislations which are dealing with the present juncture as well. As we have already been noted that the Environment Protection Act 1986, the Biological Diversity Act 2000, Forest Rights Act 2006, then as many as the legislations which are dealing with forest, like Wildlife Protection Act, are all actually based on colonial mindsets or colonialism or common law approaches. What is common law here? Common law has got its own technical meaning, please remember. Then what is civil law? What is civil law? What is common law? How will you understand common law and civil law? In civil law, you give more importance to legislations and courts, but it's not so in the case of common law. Though you have given importance to legislations and the courts, the common law is actually giving more and more importance to interpret the legislations as well. How do you interpret the legislations? Therefore, the moment when you are dealing with these three main streams, please remember to understand the common law and the civil law as well. Civil law and common law should be known to you. Take for an example, except Goa, entire India has been dealing with a common law. In Goa, you can find a civil law. Except Louisiana, USA has been dealing with common law. Except Scotland, UK has been dealing with common law. So, except Quebec, Canada has been dealing with the common law. So, what is all about common law and civil law? You should be known very little. Otherwise, it's very difficult to understand the colonial legislations as well. So, looking into the perspectives on personal laws, Saxons were actually governed under Saxon law, Hindus were actually governed under Hindu law, Muslims were actually governed under Muslim law. Similarly, Christians, all these people were actually governed under their own personal law. Your marriage is personal, please remember. Family matters like marriages and inheritance have seen a mix of reform, codification, retention of customary and religious laws as well. So most of these personal laws were also based on colonial mindsets. Take for an example, Hindu law, Mohammedan law, Christian law, then Special Marriage Act 1954, Foreign Marriage Act 1969. So all these legislations are always are actually based on the colonial mindsets as well. That you have to work on, isn't it? When you have gone through your the constitution, when you are running with your legislature, executives, and the judiciary, you should have independent approaches to work on the local issues and the challenges as well. Looking into the perspectives on rule of law, as I said, rule according to law, nobody is actually superior or inferior. All are equally footing. And you cannot be a stronger by exploiting others when you deal with the rule of law. Rule of law is a supreme eye of law. Law is supreme. Constitution is supreme. Please remember, Constitution is supreme. That you should understand on the basis of the rule of law as well. The concept of rule of law itself, while adapted, carries legacies from the colonial era. Of course, these are the serious, what shall I say, criticisms you are finding. But you should know how to overcome the problems in connection to the rule of law as well. Take one example. You just go through some of the interesting cases decided by Honorable Supreme Court of India, especially Sajjan Singh case, Shankari Prasad's case, Golaknath's case, S.R. Bommai's case, Vishaka versus State of Rajasthan's case, to say, Keshananda Bharati versus State of Kerala. Just see all these cases. These cases are actually decided on the basis of earlier mindsets as well. Please remember. Even in otherwise manner, when you deal with problems of a tribals country like India, Godavaran's case, terrorist projects case, Narmada Bajao Andalan's case, all these cases were actually decided on the basis of deforestation and the afforestation observations as well. Deforestation andreno, afforestation andreno. Deforestation was actually introduced by British. They wanted to have wood from south. That's why they introduced deforestation in Asian, South Asian and South African countries. They wanted to have wood from south. They cannot construct their homes based on concrete cement. They die. So that's why they wanted to warm up their body. To warm up their body, they want to construct their homes based on wood as well. That's why they introduced deforestation, especially in South African and South Asian countries as well. They took away everything based on their colonial or colonial mindset or colonialism as well. This is very serious issue you have to think about on the basis of how, in what manner the colonial mindsets were responsible for our vulnerability as well. And moreover, if rather I would say, the inheritance and personal law, the rule of law are always actually based on, what shall I say, the colonial mindsets as well. When you are dealing with law, society, and the politics in the colonial era, you shall not be forgotten on types of law as well. How, in what manner, types of law should be called and looked into. You have criminal law, terrorism law, civil law, international law, cyber law, family law, employment law, labor law, commercial law, intellectual property law, torts, medical law. All in all, here, law is a honeymoon subject, if rather I would say. Law is a honeymoon subject. It connects to many places as well. Remember, we deal with even politics, we deal with economics, we deal with history, we deal with genetic engineering, we deal with biotechnology, microbiology, physics, chemistry, all in all. Law is there everywhere. It is there even in outer space, seabed, subsoil, ocean floor, and Arctic. It is there for centuries. Please remember, law is not so simple subject as well. And moreover, if rather I would say, political science and law, they should go hand in hand. They are all actually honeymoon subjects. This is what I have known. Without society, there is no law at all. Without politics, there is no law at all. Politics, law, society, and rest of them, they should go hand in hand. That's why we are just dealing with the types of law as well. What is law? With a view to define law, many scholars have come. They include even Aristotle, Plato, Socrates, Machiavelli, then Herbert Spencer, for example, Max Weber. See, in this way, you have to understand what is the concept of law. Perhaps you may have gone through one of the definitions given by John Austin. John Austin defines law as the command of sovereign backed by sanctions. He says law should be framed by superior to the inferior. This is called as law. On the other hand, in natural law philosophy, for example, Thomas Aquinas, who could say that there shall be dictate of right reason. Dictate of right reason is called as law of the land. On the other hand, Carl von Savigny of Germany, who says law grows with growth, strengthens with strength, and finally dies away when nation loses its nationality, is called as law. So I am just sharing all these examples. First of all, you have to understand what is the concept of law. What is law? What is rule? What is regulation? What is bylaw? What is ordinance? What is addendum procedure? So what kind of legislations you have, policies you have, schemes you have. Each has got its own definition. That should be known when you deal with the concept in which I have selected for presentation of paper before you. What is law? What is society? And the politics as well. Without politics, there is no law at all, isn't it? Perhaps you may have gone through, Greek philosophy thoroughly. Without understanding Greek philosophy, how will you understand others? You have to have a look on philosophy. What is philosophy? Philosophy is nothing but higher levels of generalization. It's a deep-rooted knowledge. It is not actually based on a short mind or half-minded. You know very well that half knowledge is most dangerous. Half knowledge is most dangerous. Please remember. The way are you studying on Aristotle's philosophies? Even today, they are applicable in almost all the centuries. Problems throughout the world are remained. They are there everywhere. Bear in mind. This is one thing. On the other hand, to suggest you to overcome all these, I'm just sharing with you on the basis of cultural change in the society. We need to have cultural change. ಸಾಮಾಜಿಕವಾಗಿ ನಾವು ಬದಲಾವಣೆ ಆಗಲೇಬೇಕು. ಸಾಮಾಜಿಕವಾಗಿ ನಾವು ಬದಲಾವಣೆ ಆಗಲಿಲ್ಲ ಅಂದರೆ ಈ ಸಮಸ್ಯೆಗಳು ಹಾಗೆಯೇ ಮುಂದುವರಿಯುತ್ತೆ. ಸಾಂಸ್ಕೃತಿಕವಾಗಿ ಸಾಮಾಜಿಕವಾಗಿ ನಾವು ಬದಲಾವಣೆ ಆಗಲೇಬೇಕು. ಬದಲಾವಣೆ ಜಗದ ನಿಯಮ. ಬದಲಾವಣೆ ಆಗ್ಲಂಗೆ ನಮ್ಮನ್ನ ನಾವು ಅರ್ಥ ಮಾಡ್ಕೊಳ್ಳಂಗೆ ಬೇರೆಯವ್ರನ್ನ ಹೆಂಗೆ ಅರ್ಥ ಮಾಡ್ಕೊಳಕ್ಕಾಗತ್ತೆ? ಬೇರೆಯವ್ರನ್ನ ಬಗ್ಗೆ ನಾವು ಜೀವನ ಮಾಡ್ಬೇಕಾದ್ರೆ ನಮ್ಮನ್ನ ನಾವು ಅರ್ಥ ಮಾಡ್ಕೋಬೇಕು, ಬೇರೆಯವ್ರನ್ನೂ ಅರ್ಥ ಮಾಡ್ಕೋಬೇಕು. ಹಾಗಿದ್ರೆ ಮಾತ್ರ ಸಮಾಜ ಉದ್ಧಾರ ಆಗ್ತವೆ. ಬೇರೆ ಯಾವ ಕಾರಣಕ್ಕೂ ಉದ್ಧಾರ ಆಗಕ್ಕೆ ಸಾಧ್ಯನೇ ಇಲ್ಲ. ನೀವು 10 ಕಾನೂನಲ್ಲ, 10 ಅಂತಾರಾಷ್ಟ್ರೀಯ ಒಡಂಬಡಿಕೆಗಳು, ಸಾವಿರಾರು ಲೆಜಿಸ್ಲೇಷನ್ಸ್ ಮಾಡ್ಕೊಳ್ಳಿ, ಸಾವಿರಾರು ಕಾನೂನುಗಳು ಮಾಡ್ಕೊಳ್ಳಿ, ಸಾವಿರಾರು ಸಂಸ್ಥೆಗಳನ್ನು ಮಾಡ್ಕೊಳ್ಳಿ, ಆರ್ಗನೈಸೇಷನ್ಸ್ ಯಾವುದಾದ್ರೂ ಮಾಡ್ಕೊಳ್ಳಿ, ಅದು ಯಾವುದು ಕೂಡ ಸಿಂಧು ಆಗೋದಿಲ್ಲ. ನಮ್ಮನ್ನು ನಾವು ಅರ್ಥ ಮಾಡಿಕೊಂಡು ಬೇರೆಯವರಿಗೆ ಅರ್ಥೈಸೋದಿದೆಯಲ್ಲ, ದಟ್ ಈಸ್ ಅವರ್ ಕಲ್ಚರ್. ದಟ್ ಈಸ್ ಅವರ್ ಕಲ್ಚರ್. ನಾನು ಯಾಕೆ ಹೇಳ್ತೀನಿ ಅಂದರೆ, ಸಾಂಸ್ಕೃತಿಕವಾಗಿ ಬದಲಾವಣೆ ಆಗಬೇಕು ಮನುಷ್ಯ. ಯಾವಾಗ ನೀವು ಸಾಂಸ್ಕೃತಿಕ ಬದಲಾವಣೆ ಆಗ್ತೀವೋ ಆವಾಗ ಒಂದು ಒಳ್ಳೆಯದನ್ನು ನೀವು ಕಾಣ್ಬೋದು ಸೊಸೈಟಿಯಲ್ಲಿ. You get very good peaceful life in the society. That's what I said in several platforms. Peace has to be called and looked into. Peace, it does not mean it is an absence of war. Peace means presence of justice. We need to understand justice as well. So therefore, in this way, when you deal with the society, there are 3 paramparas. ಋಷಿ ಪರಂಪರಾ, ಜಗದ್ಗುರು ಪರಂಪರಾ, ದೆನ್ ಜನ ಪರಂಪರಾ. ನಾವು 3 ಪರಂಪರೆಗಳನ್ನು ನಾವು ನೋಡ್ತೀವಿ. ಋಷಿ ಪರಂಪರೆಗಳನ್ನು ನೀವು ಋಷಿ ಪರಂಪರೆಗಳನ್ನು ನೋಡುವಾಗ ವ್ಯಾಸ ಮುನಿಗಳು ನೋಡ್ತೀವಿ, ವಾಲ್ಮೀಕಿಯವರು ನೋಡ್ತೀವಿ, ಬೇರೆ ಬೇರೆ ಎಲ್ಲ ಋಷಿ ಮುನಿಗಳು ನೋಡ್ತೀವಿ. ಜಗದ್ಗುರು ಪರಂಪರೆನೇ ಬೇರೆ, ಜನ ಪರಂಪರೆನೇ ಬೇರೆ, ಈಗಿರೋ ಪರಂಪರೆನೇ ಬೇರೆ. ಅದನ್ನ ನಾವು ಅರ್ಥನೇ ಮಾಡ್ಕೊಳ್ಳಿಲ್ಲ. ಯಾರು ಏನನ್ನು ಓದಲಿಲ್ಲ ಸರಿಯಾಗಿ, ಬರೀ ಟೀಕೆ ಮಾಡೋದಾಗೋಗ್ಬಿಟ್ಟಿದೆ ಜೀವನದಲ್ಲಿ. ದಿಸ್ ಇಸ್ ವೆರಿ ಸೀರಿಯಸ್ ಇಶ್ಯೂ. ಸರಿಯಾಗಿ ನಾವು ಸಂವಿಧಾನ ಓದಲಿಲ್ಲ, ಟೀಕೆ ಮಾಡೋದನ್ನು ಬಿಡಲಿಲ್ಲ. ಸಂವಿಧಾನ ಓದಿದ್ರೆ ಈ ಸಮಸ್ಯೆನೇ ಬರ್ತಾ ಇರಲಿಲ್ಲ ಈ ದೇಶದಲ್ಲಿ. ಯಾರು ಸಂವಿಧಾನ ಸರಿಯಾಗಿ ಓದಲಿಲ್ಲ. ಪ್ಲೀಸ್ ರಿಮೆಂಬರ್, ಇನ್ಕ್ಲೂಡಿಂಗ್ ಮೀ. ಪ್ಲೀಸ್ ರಿಮೆಂಬರ್. ಬೇರೆ ಥಿಯರಿ ಹೇಳ್ಬಿಡ್ತೀವಿ, ಯಾವುದು ಪಿತ್ ಅಂಡ್ ಸಬ್ಸ್ಟೆನ್ಸ್, ಕಲರಬಲ್ ಲೆಜಿಸ್ಲೇಷನ್, ಡಾಕ್ಟ್ರಿನ್ ಆಫ್ ಸೆವೆರಬಿಲಿಟಿ, ಡಾಕ್ಟ್ರಿನ್ ಆಫ್ ಎಕ್ಲಿಪ್ಸೆ, ದೆನ್ ರೂಲ್ ಆಫ್ ಲಾ. ಸೊ ಇಷ್ಟು ಹೇಳಿ ಕೈ ಬಿಟ್ಟು ಬರೀ ಕ್ವಾಲಿಫಿಕೇಶನ್ ತಗೊಳ್ತೀವಿ, ಅಷ್ಟು ಬಿಟ್ರೆ ಇನ್ನೇನು ತಗೊಳ್ಳಿಕ್ಕಾಗಲಿಲ್ಲ. ದಿಸ್ ಇಸ್ ವೆರಿ ಸೀರಿಯಸ್ ಇಶ್ಯೂ. ಯು ಹ್ಯಾವ್ ಟು ಥಿಂಕ್ ಅಬೌಟ್ ಇಟ್. ಬಿಕಾಸ್ ಐ ಆಮ್ ಜಸ್ಟ್ ಅಡ್ರೆಸ್ಸಿಂಗ್ ಟೀಚರ್ಸ್ ರಾದರ್ ದ್ಯಾನ್ ಸ್ಟೂಡೆಂಟ್ಸ್ ಆಸ್ ವೆಲ್. So you have to understand in this way, the moment when you are just dealing with the law, society and the politics as well. Apart from these, there are as many as schemes which are introduced by our governments. Take for an example, you have national old age pension schemes, midday meals schemes, Annapurna Yojana. Then you have Sampurna Gramina Rozgar Yojana. You have Narega. Then Indira Gandhi Awas Yojana, Swarna Jayanti Yojana. Then you have RTI, RTE. All these legislations have come in. They are within you. ನೀವು ಪಕ್ಕದ ಶ್ರೀಲಂಕಾಕ್ಕೆ ಹೋಗಿ, ರೈಟು ಇನ್ಫಾರ್ಮೇಶನ್ ಆಗ್ತೇ ಇಲ್ಲ ಅಲ್ಲಿ. ನಮ್ಮ ದೇಶದಲ್ಲಿರ್ತಕ್ಕಂಥ ಸಂವಿಧಾನದ ವ್ಯವಸ್ಥೆ ಬೇರೆ ದೇಶದಲ್ಲಿ ಇಲ್ವೇ ಇಲ್ಲ ಹೇಳ್ಬೇಕು ಅಂತಂದ್ರೆ. ಅಷ್ಟು ದೊಡ್ಡ ಇರ್ತಕ್ಕಂಥ ಸಂವಿಧಾನನ ನಾವು ಅರ್ಥ ಮಾಡ್ಕೊಳ್ಳಿಕ್ಕೆ ಆಗಲಿಲ್ಲ. ದಿಸ್ ಇಸ್ ವೆರಿ ಸೀರಿಯಸ್ ಇಶ್ಯೂ, ಇಫ್ ರಾದರ್ ಐ ವುಡ್ ಸೇ. See, apart from these, no matter, the nature of Indian state has shifted over time from a focus on nation building and welfareism to a more market-oriented approach. In essence, post-colonial Indian politics has been a dynamic process of adaptation, transformation, and contestation, and shaped by both internal and external factors as well. As I said, each state is supreme in eye of law. It can possess internal and external economic sovereignty as well. Economic sovereignty should also be actually called and looked into. This is what I'm just appealing you to have a look on. The legacy of colonialism, the pursuit of economic development, and the assertion of diverse social identities continue to shape the country's political aspects as well. See, apart from these, if rather I would say, the post-colonial Indian politics is in fact characterized by transition from British colonial rule to a democratic nation, shaped by Nehruism ideas, economic reforms, and the rise of civil society. And moreover, if rather I would say that India's political landscape has evolved through various phases, including the initial focus on nation building under Nehru, the subsequent challenges of economic development and social change, and emergence of new political focus and ideologies as well. That is what I could refer one of the statements given by Stephen Wago of United States of America. who defines in this way. Law is an instrument of social change. It may change from time to time as a science and technological development as well. So we need to have, what shall I say, the cultural change in the society as well. Looking into the perspectives on Nehru, Jawaharlal Nehru vision on the politics as well. Nehru, as the first prime minister, established a framework for post-colonial India with a strong parliamentary democracy. We need to understand parliamentary democracy, a mixed economy, and non-alignment in foreign policy as well. Perhaps many scholars may have known about national power and the foreign policy, how national power and policy should be looked into, how a state would be called as if a big power, superpower, or big brother. At the international level, there are some inputs to understand the national power. So without understanding the elements of national power, whatever you are going to say would be incomplete. Perhaps you may have known what are the elements of national power. You have geography, population or demography, military, technology, natural resources, then psychology, good leadership qualities. These are the inputs of the national power. What is the national power? You have to show your strength or capacity at the international level. Why USA has become superpower? Because of good geography, leadership qualities, then softer diplomacy. All these things should be the basis with a view to understand the concept of national power as well. These are the things should also be actually called and looked into. The moment when you are just dealing with the politics in colonial era as well. The constitution adopted in 1950 established a democratic republic with a parliamentary system at both federal and state level. That's why you are just understanding on the basis of democratic institutions as well. As long as you are dealing with the democratic institutions, so long you shall not be forgotten on economic development. So India, in fact, adopted a mixed economic approach with a state playing a significant role in development while also allowing for private sector participation as well. Here you have to recollect LPG system, you know very well, better than me. Liberalization, privatization, globalization. Because of LPG system, you have given more importance to the privatization as well. This is one thing. Apart from this, so what are the challenges and transformations you have when you deal with the politics in colonial era as well? Looking into economic stagnation, this is one of the serious issues we have in India. The Nehruvian model faced challenges related to economic growth and social inequalities are also there that you should understand when you deal with the economic, what shall I say, stagnation as well. Apart from economic stagnation, look into social tensions, caste-based and religious divisions became more pronounced, impacting political mobilization and the policy making as well. Most of the time, policies are also based on caste, color, greed, and religion as well. What is religion here? Religion is a pathway to realize the God. Religion is a pathway to realize the God. You may be belonging to any religion of your choice. This is what Article 25 of the Constitution of India, which has given you some inputs to understand what is all about religion as well. Religion is a pathway to realize the God. But in the name of religion, you have killed many, seriously speaking. and you have coined them indifferently. Of course, you have a ready-made answer. Then what kind of ready-made answer you have? Ultimately, you may say that there shall be harmony between religious mannerisms. How in what manner you are going to understand religious harmony? And you know, the fact that one of the neglected articles in the Constitution of India is Uniform Civil Code. This issue is remained even today. This topic is good enough for dissertation and the PhD work, that's all. Not for understanding others. Bear in mind. So therefore, you have to have a look on Uniform Civil Code. How in what manner Uniform Civil Code will be helpful on the basis of a religious harmony. All religion should go hand in hand. All religions are equally footing. Sarva Dharma Samana concept should be called and looked into. Each religion is equal. So equality before law and equal protection of law should be looked into when it deal with social tensions as well. This is one thing. On the other hand, authoritarian turn is also one of the serious issue when you deal with the politics in the colonial era as well. Indira Gandhi's leadership saw periods of authoritarianism, including the emergency, which raised the question about the democratic norms as well. That's in history. You cannot say in otherwise manner as well. So these are the major crises we have. Apart from these crises, you have economic liberalization, rising of civil society, new political ideologies as well. When you're dealing with new political ideologies, see the new nationalism, which is called as Hindutva, and other ideological gained prominence, challenging the secular and the socialist foundations of Nehruvian era as well. So all these issues are actually well noted here and there. And then regional parties played an increasingly important role in national politics, reflecting India's diverse regional identities as well. Apart from these, India's role in the international arena expanded with a focus on economic growth and strategic partnership, and more assertive foreign policy as well. We have to understand our own policy, like Indian foreign policies as well. Of course, most of the scholars who have outspoken, they include in Palmer Perkins, then Hartman, then Hans Margenthaler, especially in politics among the nations. Yeah, Hans Margenthaler, who could say that foreign policies are always based on domestic policies. So domestic policies and the foreign policies should be looked and verified once again the moment when you are just taking part in international issues and challenges as well. So these are the things which shall also be actually looked into the moment when you are just dealing with the politics in colonial era. This is one thing. On the other hand, the moment when you are dealing with the transformation of international law into the municipal law, there are as many as the theories have come in. Take for an example, you have monism, dualism, specific adoption theory, transformation theory, incorporation theory, pluralistic theory, theory of harmonization. So all these theories have come in. They are within you to understand. They are all actually based on academic purposes rather than just tackling, practical situations as well. So you have to understand how, in what manner you're going to have, very good the relationship between municipal law and the international law as well. I must share with you, as you have already been known, that uh, international is not, in fact, harmful to the municipal law. It is supplementary, complementary, and residuary to the municipal law. Any gaps to be filled at the local level, obviously public international law would prevail over the subject to resolve the matter on time. I think you have to have a very good relationship between municipal law and international law to overcome the local issues as well. That's why even O'Connell, one of the celebrated authors of public international law, in his book, who could share that there shall be coordinated approaches between municipal law and international law. You shall not be more emotional. Emotional. Emotionalism is one of the major setbacks of any research scholar. Please remember, this is what F.L. Whitney, in his book, Elements of Research, who could share one of the one of the one of the bad practices of a researcher is emotionalism. Don't be emotional on either subject. Either it could be municipal or international law. See, both international and municipal law, they should go hand in hand to overcome all these maladies or issues and challenges we have here and there. This is one thing I would like to share with you. Then, as long as you are dealing with this subject matter, as we have been actually suggested to address, the role of identity politics is also uh, looked into, is also to be looked into. Take for example, caste, religion, regional identities continue to be significant factors in Indian politics, influencing electoral outcomes and policy decisions as well. This is one thing. On the other hand, the post-colonial theory, in fact, examines the lasting impact on colonial rule on Indian society, culture, the political structure as well. This is one thing. On the other hand, the nature of Indian state has shifted over time from a focus on nation building and welfareism to more market oriented approaches as well. This is somewhat should be called and looked into. On the other hand, the moment when you're just dealing with the legal system in India, in post-colonial India, for example, the legal system reflects both continuities with and departure from its colonial past, while some colonial era laws were actually retained, new laws and interpretations emerged, particularly in the area like civil liberties, equality, and social rights shaped by Indian Constitution, subsequent judicial decisions. Then the legal landscape is characterized by complex interplay of inherited legal frameworks, nationalistic aspirations, and evolving social realities as well. So this is very essential with we to understand the synergy between these three main streams as well. Apart from this, when you deal with the codified laws, no matter many fundamental laws like Indian Penal Code, now you are called as Bharatiya Nyaya Samhita. Earlier, it had to be called as if Indian Penal Code. The Code of Criminal Procedure Code 1973, then the Indian Evidence Act 1872. All these specific legislations were all like, are all actually based on the colonial mindset. To overcome colonial mindset, especially in 2003 or 2023, in fact, we could pass new legislations. Take for an example, Bharatiya Nyaya Samhita, Bharata Suraksha Niti, then Bharatiya Sakshi Adhiniyama, like Indian Evidence Act. All these acts were actually replaced as if as to overcome the colonial mindsets as well. Is one thing. See, while the rule of law was also a colonial concept, as you have already been uh, experienced. Rule of law was ultimately actually based on the colonial mindset. It has been adopted and reinterpreted in the past colonial context with the Indian Supreme Court, playing a significant role in shaping its applications as well. So now, somehow, we have been actually streamlining to overcome the uh, colonial mindsets as well. Is one thing. On the other hand, the system of personal laws governing the matters like marriage, inheritance, based on religions and customary practices was a key of both colonial and post-colonial India. While attempts at reforms and unification have been made, the system continues to be complex area of the legal practice as well. So of course, no matter, lot of changes have occurred even after establishment of our own constitution as well. See, since 1950, we have been actually heralded transformational changes, especially in the working administration of justice, country like India as well. That shall not be forgotten, especially in labor legislations as well. We have Factories Act 1948, Industrial Dispute Act 1947, Bonus Act, Gratuity Act. All these legislations were actually all these legislations were actually based on the new outlooks as well. Of course, no matter, depending on the developments that are taken place at the international level. Uh, in fact, as you have already been known, is also putting its efforts with a view to overcome the local issues and the challenges as well. Take an example, problems in connection to um, elderly or physically challenged or able. Seriously speaking, many legislations were drafted with a view to understand what shall I say, the rule of law as well. On the other hand, the Supreme Court and High Courts have played a crucial role in interpreting laws addressing issues like civil liberties, equality, and social justice as well. Say, for example, as long as you are dealing with social justice, you shall not be forgotten on atrocities against SCs and STs as well. How in what manner atrocities are supposed to be looked into? Seriously speaking, we have had our own special laws. Few special laws were actually passed with you to understand the problems of the people who have come from a little background, none other than SCs and STs as well. Just go through section 18A of the Atrocities Act 1989. There are transformational changes have occurred in this section as well. To uphold this section, Prithviraj Chauhan was actually filed an application before Honorable Supreme Court of India. Now, this case is called as Prithviraj Chauhan versus Union of India. This is very good development at the what shall I say, higher level as such. Supreme Court of India is not actually keeping quiet every day. It is actually interpreting the laws with a view to help the people who have come from a little background. Take an example, it could be women, children, orphans, LGBT sex, physically challenged or abled, or what shall I say, refugees, internally displaced persons. All these issues have been actually overcome on the basis of efforts made by high courts and the Supreme Court under Article 226 and 32 of the Constitution of India as well. I must share with you Article 32, that itself is called as Art of the Constitution. Everybody knows this is what Dr. B.R. Ambedkar said long ago. Without understanding right to remedy, whatever you are going to say under part third would be incomplete. That's why I must share with you right to remedy, that itself is a fundamental right. Ibi just ibi remedium. Where there is a right, there is a remedy. Where there is a society, there is a law. Society, law, and politics should go hand in hand. So, without understanding this, whatever you are going to say would be incomplete. This is what I would like to share with you. So, what are the changes or reforms you have? especially in criminal law, lot of changes took place. Then nationalism, uh, decolonization, then social justice, environmental law, international. Just see all these streams. You'll be known how, in what manner you have transformed with many changes and the laws as well. So therefore, based on the efforts made at the higher level, or you are witnessing all these changes and the reforms as well. Thanks to higher judiciary and the statesmen who were responsible uh, for overcoming all these issues and the challenges as well. See, continuities and the changes you have, like, Indian law in post-colonial era reflects both continuities and departures from colonial legal system. You have personal laws, public interest litigations can be filed before honorable courts to understand the local issues. Any arbitrary actions given by a state, you can react, you can have compensation from the court as well. That's why people are knocking the doors of judiciary. They need justice. That's all. You have to give voice to the voiceless, eyes to the eyesless, remedies to the remediless. Access to justice is one among human rights. Please remember, on the basis of public interest litigations as well. But the fact that the moment when you are filing a public interest litigation, you should have a locus standi. You should have grounds for filing a case. So you have to be very careful the moment when you are filing PIL, public interest litigation, before high courts and the Supreme Court as well. You should go along. You should go along with all the grounds. Sound evidences should be made available. So without uh, understanding these, it's very difficult to win the case before the court of law as well. This is one thing. You have social justice, caste discrimination, identity politics, social transformation. All in all, about all you have legal profession. So lawyers are social engineers. However, you may be finding some criticisms leveled against uh, the advocacy. Lawyers are also shaping entire society as a whole. So in this way, you have to understand even from the perspective of the social justice as well. As long as you are just dealing with the statements given by V.R. Krishna in many cases, in fact, you shall not be forgotten on some more observations made by uh, Justice Subbarao, Justice Bhagavati, Justice Khanna, H.R. Khanna, for example, then Hidayat. All these judges were, in fact, instrumental in understanding the concept of social justice. Social justice is to be looked into. Without understanding social justice, whatever you are going to say would be incomplete. Social justice is one of the bases that you should understand. See, when uh, uh, Granville Austin was actually writing something about Indian Constitution, he could say that Indian Constitution that itself is called as a social documentation. You have to understand this society in a better way. This is called a social document. Yeah, this Constitution came in on the basis of the society as a whole. You have to understand in this way.